So very privileged to hear from the Honorable Chile Ebo Asuje, the former president of the International Criminal Court. So please join me in welcoming him.
Thank you, everyone. Thank you for that lovely introduction, the best so far. Now, here's the story. Is anyone following, does anyone here, apart from Craig Martin, Professor Martin, follow the news in Canada? All right. I'll tell it. I mean, I think 3-4 days ago, the Speaker of Parliament resigned, and Barbara, here's your story. President Zelensky had a whirlwind tour of North America, from New York to Washington, and then he came to Canada, addressed Parliament. Of course, as people heard, the president of Ukraine was coming to address Parliament, as someone from the Speaker's constituency writing, who went to the Speaker and said, "Wow, we have a 98-year-old Ukrainian war hero in your writing." So the Speaker invites this gentleman to Parliament. So there he is sitting in the public gallery when Zelensky is addressing Parliament. And then the first thing was to introduce the gentleman, 98-year-old, as a war hero, Ukrainian war hero. The Speaker also called him a Canadian war hero for that reason. And the Prime Minister, President Zelensky, and the entire Parliament got up and gave him, the gentleman, a rousing ovation, standing up. And then after the event, someone tweeted the Canadian Parliament had actually cheered somebody who fought on the side of the Nazis during the Second World War. The result was that the Speaker had to resign. This is a new story. Why do I say that? It is about how the war in Ukraine continues to have repercussions beyond Ukraine, even as we speak. When I wanted to speak about this, Michael said, well, as long as you make it relevant, the right to peace you want to talk about, to environment, go ahead and speak. He said, sure. It's not it's not difficult to make the connection between the war in Ukraine and the environment, the damage to the environment. And we saw earlier Giovanni Chiarini put up some slides that sets up more or less what I would have liked to say. In picture, earlier this summer, in words, let me approach some of that in words as well. Earlier this summer, the New York Times ran a piece in colorful terms titled, "A Silent Victim, How Nature Becomes a Casualty of War." Begins the story, or the piece, quote, "The Black Sea Biosphere Reserve on the southern coast of Ukraine is a haven for migrating birds. More than 120,000 birds spend the winter flitting about its shores, and a multicolored spectrum of rare species, the white-tailed eagle, red-breasted merganser, and black-winged stilt, to name just a few, nest amongst its protected waters and wetlands. The reserve is also home to the endangered sandy blind mole rat, the Black Sea bottlenose dolphin, rare flowers, countless mollusks, dozens of species of fish, and in recent weeks, an invading military. But military activity continues apace in the area, sparked fires large enough to be seen from space prompting concerns about the destruction of critical bird breeding habitats. Unquote. I'll leave it at that. But the only thing that's destroyed, as we know, is not just bird breeding habitats. As Professor Sadat said, we link the consequences, the drastic consequences of destruction of environment to our own survival as human beings, and we call that crimes against humanity. Now, the war in Ukraine, as much as we can feel sometimes that all we've been doing has been to talk about it, it's something we cannot escape. It leads us to ask ourselves, has this war really brought us to an inflection point in the development of international law, where we need to develop international law in ways that would add more layers of deterrence against the kind of war we see there, wars of aggression? And that's what I would like to talk about. And I move this house to say yes to that question. But in getting there, we have to appreciate the story of difficulty that often attends the development of international law. And we may begin that message of difficulties with what someone whose name we will all recognize once said: it always seems impossible until it is done. And that very much is the story of development of international law. Can we then say maybe we will give peace a certain value that will make it actionable for victims of wars of aggression to assert a certain right, the right to peace? And we'll talk about the right to peace. We begin with statements of impossibility in international law as one, that the International Institute de Droit International, I spoke about it earlier when I intervened in the last panel, something they said in 1880, quote, "War holds a great place in history, and it is not to be supposed that men will soon give it up in spite of the protests which it arouses and the horror which it inspires, because it appears to be the only possible issue of disputes which threaten the existence of states, their liberty, their vital interests," unquote. And to the Droit International Oxford Manual 1880, what they're telling us there was a proposal that lets the international community in 1880 recognize a code or a treaty on international humanitarian law to control how wars are fought for purposes of protecting people and societies. And in 1874, the 3 years before that, that proposal was made in Brussels, at the Brussels conference, and the international community then said, no, not quite, in 1870. So in 1880, you see the dons, these are professors, saying, well, we know you've taken on this thing before, but we're not going to push you too hard, but keep this in mind. Let's try harder. And they did persist, and in 1899 and 1907, the world had the first treaties on international humanitarian law. The first Hague Peace Conference of 1899 and the second, 1907, that gave the international community the first slew of what you really call far-ranging multilateral treaties. So right there in 1880, it was seen as a very difficult thing for international communities to agree to such treaties, let alone the idea of making aggressive wars, outlawing aggressive wars in international law, let alone beyond making aggressive wars illegal, to make them criminal. You could not think about those prospects in 1880. That was a statement of impossibility. Now, another statement of impossibility, move forward, 1950. Now, there's an institution we all nowadays take for granted, so much so that some of us, John Bart and I, when we criticize it for its shortcomings, here we see someone saying this. In my opinion, the cons outweigh by far the pros. A permanent judicial criminal organ established in the actual organization of the international community will be impaired by very serious defects and will do more harm than good. The time has not come to do that, 1950. And actually, this was one of the two rapporteurs of the International Law Commission, Judge Emil Sandström of Sweden, who rendered this view about the prospect of creating a permanent international criminal court. Luckily, the world had the other rapporteur, Dr. The former Panamanian President Alfaro, who spoke more positively, said, look, it is desirable, it is needed, let's move forward. And the ILC voted in favor of Dr. Alfaro's proposal. Now, realization of those impossibilities, in 1880, IHL treaties deemed something the world was not ready for, but in 1899, 1949, 1977, and thereabout, and so on and so forth, we have those treaties in place. Proscription of aggressive wars as unlawful in international law, a difficult proposition in 1880, realized in 1920, 1928, and so on. Criminalization of wars of aggression, again, something you could not contemplate in 1880, realized in 1945, 1974, and 1998. The establishment of a permanent ICC, again, a difficult proposition in 1950, realized in 1998. Now, here's another quote of interest to us, another kind of judicial institution that we all take for granted. Here you have the creation of the Permanent Court of International Justice. When it was done in 1922, someone said, well, the establishment of the PCIJ should have given every lawyer a thrill of cosmic vibration. Another eminent lawyer, these are people you know, you'll get the names in a minute, that the one dream of our ages has been realized in our time. Who are these? Wigmore and Brown scored names, stalwarts in the American Academy. Legal Academy. Manlio Hudson, what does he say about the creation of the PCIJ in, a world tribunal for the adjudication of international disputes is at last a reality. On January the 30th, 1922, for the law students who may not have this history, here you go, 1922, the 11 judges of the PCIJ are scheduled to meet at The Hague, and their assembling will crown the success of a whole generation of determined effort. The ideal of such a tribunal has been stirring in the minds and hearts of men for centuries. A Frenchman, Pierre Dubois, suggested it in 1305. Another Frenchman, Émeric Crochet, in Le Nouveau Ciné, published in 1623, gave it definition and direction. I'll stop there. You see how long people had been clamoring, hoping for an international court of justice. Realized eventually in 1922, 1922, and we ask ourselves, is it possible for that kind of history to give us hope that at some point we will recognize peace as a basic human right in actionable terms? When I say actionable, in terms of that famous quote, ubi ius ibi remedium, where there is a right, there is a remedy. Where the right is violated. Can we do that with peace is a desirable thing to hope for? Is it even feasible to do that? And that's the question. Desirable? Well, let's look at the desirability. Begins with how, or a certain angle from which we can approach peace and see it as something we all take for granted. It's a notion. If we stopped to consider the matter, I think we will all accept that peace is the substratum upon which almost all the other rights we take for granted, right, are based. The substrate right, a basic right, I would say. Some of you may recognize that in the future days, which we seek to make secure, we look forward to a world founded upon 4 essential freedoms, right? And that was the famous quote of FDR's at the height of the Second World War. The 4 freedoms: freedom of speech, freedom of every person to worship, freedom from want, freedom from fear, all over the world, not just in the United States. And one would think that this is the kernel, as it were, of the idea of fundamental human rights recognition at the international stage. And that's what he was presaging there. And we see those fundamental, again, stop to say, is there any of those 4 freedoms you could really meaningfully enjoy where you don't have peace? We take it for granted, but that's one question we must ask ourselves. The fundamental human rights that we now recognize, Professor Knox earlier on gave his own slides. I will reprise those. I did not borrow this from him, I promise. He and I met today for the first time. But here we are, setting out the same kinds of rights. A right to life under civil and political right, liberty and security of the person, freedom of movement, freedom of thought, conscience and religion, right to peaceful assembly, freedom of association, right to family life, civil and political rights, and the economic, social and cultural rights. Much of the world have recognized the idea in their constitution and in ratification of the Convention on Civil, Covenant on Civil and Social, Covenant on Economic, Social and Cultural Rights, right to work, right to unionize, right to social security, adequate standard of living, health, education, cultural right. Again, which one of these rights can you meaningfully enjoy in circumstances of broken peace? That there's many. Now, when we move back at it beyond appreciation of the matter from the perspective of fundamental human rights and how peace really is the substrate human right, you can also look at peace from the perspective of the organizing of the world that we now take for granted. Remember, the world wasn't always organized on multilateral terms, but that started in 1920 with the League of Nations, 1945. But before that, the first idea of multilateral gatherings arranging the world in ways that we still recognize today as something, tell us something about international law, the idea of international law, started where? Peace of Westphalia in 1648. Here, a text out of the Peace of Westphalia. The preamble is the first quote there, and Article 1 is the second tranche, of course, that follow. In all of this, the fundamental idea is that quest for peace. We want peace. The Europeans had been fighting for 30 years in the 30-year war. Some 80, earlier than that, even the 80-year war, all resolved in the Munster and Osnabrück peace treaties of October 1648 in the 2 documents that we now call the Peace of Westphalia. Again, the purpose, what? peace. We want to organize peace, organize the world, so we can all enjoy universal peace away from the disorders of a long and cruel war. So, on the next quote I give you there, that the name of peace conference, which the popular mind of stripping a decision by the government in this respect has given to our meeting, well indicates the essential object of our labors. The labors being talked about there by the Hague Peace Conference of 1899, and this is from the text of the speech of the president of that assembly, presiding ambassador, Baron Stahl of Russia, as it were, speaking about, again, that's the first modern, should we say, multilateral international instrument. And there we need to have these instruments for the sake of peace, universal peace. And we had the first Hague Conventions and the first Hague Peace Conference and the second Hague Peace Conference. Fast forward 1919, it's a famous speech by Woodrow Wilson as he lobbied for the creation of the League of Nations. Again, there he said, beyond simply resolving this war, the First World War, we also too want to create a new multilateral institution that will preserve peace for the world. And there, eventually, he managed to have the League of Nations created. Well, of course, the US didn't join it, but a lot of the world did welcome that initiative, and that's what has given us the UN, the precursor to the United Nations that we now take, again, for granted. The UN preamble, again, stresses, again, that importance of peace. The Charter of the United Nations scourge of war, what can we do to save humanity from that and protect fundamental human rights? And to these ends, we should practice tolerance and live together in peace with one another as good neighbors. Again, the essential pillar of the creation of the United Nations. So why are we talking about this? Why am I talking about it? Because we take for granted all these institutions we have. The United Nations, we take for granted the institutions of human rights that we have in the sense of what peace, the central purpose of peace, or the fundamental purpose of peace in these endeavors. If that is the case, isn't it time for us to come up and actually give peace that value that it deserves as a juridical value, a legal value, a human rights value that can be enforced when that value is attacked by wars of aggression, especially those that would have repercussions for the environment. A question was asked when Professor Knox was speaking earlier about customary international law in relation to the environmental protection. Here, I want to take that. I anticipated that question. Could we say that the right to peace, by some construction, some argument, might have achieved the status of customary international law? Now, it is an arguable proposition. Again, I tend to be optimistic about these things. It is arguable. Up on the text, is on the screen there is a passage from Acost's Modern Introduction to International Law. I use it to teach public international law. Acost's, the text tells us something a lot of authors agree with. And that is to say that, well, when we conceive of customary international law, let's not forget that we can get that from resolutions of the United Nations General Assembly in particular. And the thinking being, well, the binary, again, elements of customary international law, state practice plus your opinio juris, state practice being what states do and say. And the usual place you want to look at that is what states say and do from their capitals, from the various capitals. Have they said it enough with psychological resolve that they are either following the law or want to lay down the law? If you have that in appreciable, quantity, you can say, yes, customary international law has evolved. But then if you stop to say, okay, well, do we have to always track this from what states say and do from their various capitals? What is the best place to look for what states say and do in relation to foreign relations? Well, one will say, well, when you put them all together in one room, as we all gathered here, and that's what they do at the UN General Assembly, you're all in one room dealing with one particular subject matter. You're not left to think about it from your own various angles, capitals, but you're in one room. We have a question here we are discussing. What do we all think about that? So the minds are pointed to that question at that particular moment. And those who don't have the capacity to do it from their various capitals can share knowledge from gathering in the room. And then they come up at the end of the day with certain pronouncements, call it resolutions, call it declarations. You can begin to see state practice in there, gathered in, distilled from that gathering. So that is what ACOS is saying there. And a lot of academics share that view, as do I. So in my view, the best place really to distill state practice is when states are gathered together in one place and they have to deal with a specific question on a matter. So that can give us customary international law. Now, how does that relate to peace, the right to peace? Well, but before I say that, by the way, somebody, I think it was Professor Martin earlier, also appreciates this question during his intervention. Let's not forget that the ICJ has also acknowledged that, yes, we can distill customary international law from United Nations resolutions and declarations. And here, the latest instance, one of the later instances of that pronouncement from the ICJ is the advisory opinion on the Chagos archipelago that the court rendered in 2019. We're in program 152. It does indicate, yes, you can distill, you can see customary international law from UN resolutions, but that's not the only time the court has said it. Now, right to peace. Is it possible to distill a right to peace as a matter of customary international law from what the United Nations General Assembly would have said in resolutions and declarations? And let's look at what has happened here. And watch out for this. In every of these instances where the UN General Assembly has taken up the question of the right to peace, be it right of people to peace or right of human beings to peace, as a resolution, it has always been adopted by a majority of votes. Yes, there are some states who would vote against it, but in almost every instance, and there have been several instances where this has happened, there has always been majority voting in favor. And if majority cannot help create law, I don't know how you create it then. Of course, some might rightly say, well, maybe you are oversimplifying the whole thing. Yes, I accept that. But at least we can say, to the extent that you can have groups of states, European states can agree among themselves to a certain treaty or certain norm, and then that becomes international law for them. Well, I'm not sure that that's too far removed from the idea of states gathering at the United Nations General Assembly repeatedly voting in favor of a certain proposition, that at least for purposes of the states who voted in favor of that proposition, we cannot say that a culture of a legal culture or customary international has not evolved, or at least began to evolve. So that we see in the resolutions of the UN General Assembly on the right to peace. So one instance we have in 1984, it comes here 92 votes voting. In favor, none against, 34 abstentions. And at the UN Commission on Human Rights, you have again the same phenomenon, 33 votes in 2002 to promotion of the right of peoples to peace, 15 voted against and 5 abstentions, and so on and so forth. I'm not going to delay you here. But every time you recite that question, right to peace resolution at the UN General Assembly or the Human Rights Council, you will find that invariably a majority of states would have voted in favor of that. And then one of the last major instances of this happening was in 2016. A declaration of the right to peace was a resolution of the UN General Assembly there. 131 states voted in favor, 34 against, 19 abstentions. So, can we argue from that at least, well, somebody might say, well, it might be too much to say that customary international law has already emerged. At least we can say it's on its way. That much we can say. Is it feasible to envision a rise to peace beyond the desirability of having it? I would argue again, yes, it is feasible. I don't think too many people will disagree with the desirability aspects of it. People may quibble about, well, yes, we do like the idea, and you see that in those who voted against the UN resolutions on this. Their objections are not necessarily we don't like the idea of right to peace, but we're troubled by how it is being defined. The scope of it is everybody putting in whatever troubles them. There are some places where, let me put it this way, there is no country in the world where you don't have concerns about inequality, concerns about discrimination, racial, gender, whatever, the people with disabilities, sexual orientation. In every country you have this issue, discrimination. And then are you going to couch right to peace in a way that says wherever there is discrimination, there is an obstruction of right to peace? That has been the trouble for a lot of the countries who are saying, hang on, we want to pause on this, study it some more. But is it possible to define it in a very narrow way so as to eliminate those kinds of concerns by focusing it precisely on the war of aggression? So yes, we can argue about discrimination, but here we are dealing with a radical, palpable stuff that you cannot get away from. That is that one country got up and then invaded another country. So let's begin with that and say, well, when that happens, we are talking about violation of the right to peace. Agree on that, and then we'll see where we go from that. So if we do that, in my view, then we would have achieved much. And I don't think that the story of impossibilities we've seen that later got realized would be something that should detain us, because we have seen difficult propositions come true eventually in international law. So we can see the feasibility of having right to peace that is narrowed to wars of aggression as violating the right to peace. We've seen it before. So one can then envision another international covenant on the right to peace as such. But then you say, wow, why do we wait until customary international law? Didn't you say customary international law is going along those lines? Yes, that's a good question, but a covenant, one of the values of treaties is that they crystallize a legal proposition much faster. And you have the definition of what you're talking about circumscribed in precise terms to the extent possible. So you don't have everything going at it. So you can, so that will be the value of a covenant on the right to peace. And we will be, part of that would be to deal with a certain, that's the third bullet now, a certain difficulty that we do encounter much, and Professor Leila said I spoke about it in the context of the ICC. You don't have corporate criminal accountability in the ICC, but there are many international conventions and treaties that actually recognize the liability of corporations in violation of international law. So this is something that can be done here in a specific instrument, right to peace. Will mention that corporations can be held accountable. Now, let me stop there before the lobbyists for the NRA get in on the act. When one is talking about corporate accountability for violation of the right to peace by virtue of invasion of wars of invasion, for instance, the idea is not to say that corporations that manufacture and sell weapons will be automatically held accountable for wars of aggression, or the countries that support the arms industry will be held accountable for that. There is a difference here between manufacturing and selling weapons to people for purposes of self-defense. There's a difference between that and selling people weapons for purposes of wars of aggression. The corporation that supplies weapons to state A, for instance, because the world is a dangerous place, Ukraine would like to defend itself, to supply any country with weapons so that it can do meaningful self-defense. It's not something that should attract culpability. What the problem is that the country you've supplied the weapons for purposes of self-defense engages in a war of aggression using the weapons you've supplied them. And what should be obvious to you that this country has engaged in a war of aggression, and then they basically use up the weapons you've sold to them, and they come back to you for more, and you sell them more weapons so that they can keep prosecuting a war of aggression. That is where the difficulty is. Not in the original supply of weapons for purposes of self-defense, but in the replenishment of weapons for continuation of a war of aggression. That's where the concern should be for corporations and countries. Also, one value of, and then of course you define this in the treaty, what you mean by complicity. One value of a treaty, again, would be to preclude official position or act of state immunity. It will be specifically stated that that doesn't apply. And a big advantage of that, of a treaty, would be enforcement of foreign judgments. Remember, if the model is adopted, right to peace recognized and violation of right to peace attracting liability, the adjudication will happen mostly in national courts. So all the states that are parties to that treaty, it will be applicable in that territory, regardless of who the defendant is. In other words, the Alien Torts Claims Act will be more or less superseded by this, in the sense that it is done, those treaties are adopted for purposes of making it possible for litigation to be done in every country, regardless of where the crime of aggression occurred, so that the countries who saw the need to freeze Russian assets in the various places would have those assets available for attachment in the local jurisdiction. If Ukrainians come to America and say, look, this war in Ukraine has devastated our lives, family life and our environment, so we want compensation, American federal court can render that judgment in the US, and that judgment could be used to attach frozen assets in the US, and the same judgment could be taken to go to another country that's a member state of this treaty and enforced without much complication. So that way you use a national law to enforce international law by way of recognition of foreign judgments in relation to violation of the right to peace. So in a nutshell, that would be the mapping out of this prospect of right to peace as an actionable human right. I don't think it is too much to expect. I'll leave it at that, and thank you very much for listening. How did I do with time?
Oh, I was gonna give you a full hour.
No.
Okay.
Over 3 minutes.
We're done. Okay.
Because then we have 15-minute break and then it's 2 o'clock.
We started late, so I was gonna
Yeah,
give
no,
you this
that's
full
he said he
hour.
was only going to do it.
You did great.
So, yeah, good job.
So, one question, or if any, then.
One question? Oh, can I ask you the question?
Sure.
So you started out by promising you were going to connect this to the environment. Go.
Connecting it to the environment, as I said, was easy. I think probably the easiest thing. When you have destruction of the environment, where that has been a source of life for people, if you watch some of the videos and pictures of what's happening in Ukraine, you could very well see the devastating, the prospects of long-lasting damage to the environment. And when I began the speech as well, I quoted the text from the New York Times piece. There is a piece written in at about this time last year in the prestigious medical journal, The Lancet, right, that again spoke about how the war in Ukraine has these long-term environmental implications. So definitely the connection is there, a little too obvious, I would think.
Just to follow up, if your treaty was adopted, would it give individuals an actionable cause of action?
That is precisely the point, yes.
Violations of the environment during after.
You can add it in there. That's one way where it can come in addition to other things that the treaty can do. Yes. Okay. Thank you.